Matthew Walsh, Vice President of Tax Compliance at SOPA's Compliance. Today I'd like to chat about a bill that just recently passed and will take effect in South Dakota regarding remote sellers and collection of sales tax. Senate Bill 106 was signed by the governor on March 22nd and takes effect on May 1. And this bill is a direct attempt to try and overturn the Quill versus North Dakota decision that actually was ruled by the Supreme Court in 1992. In the Quill decision, the court essentially said that if a business doesn't have a physical presence in a state, they can't be required to collect and remit sales tax in those states. That it was too difficult to try and comply with these laws, to get the information to comply with these laws, and so that without actually having a physical presence there, it was an undue burden on these businesses to try and require them to collect tax in those jurisdictions. Well, as you can imagine, things have changed greatly since 1992, and e-commerce and remote sales have exploded. The states estimate they've lost about $23.3 billion in sales taxes in 2014 on these remote sales. And the states are now trying to capture, or figure out a way to capture the tax that they are not collecting, or that their residents aren't paying on the use tax side when they buy these items tax-free. The idea of a tax-free internet shopping experience is pretty pervasive across the country. And in fact, what it is taxes are not being collected or remitted that should be, and the states are trying to figure out how to capture that revenue. And again, it all rolls back to the Quill decision and the physical presence standard. There's been several attempts over the years to try and do this. So New York initiated a law several years ago that's referred to as Clickthrough Nexus, meaning if there's a business who has a physical presence in the state and they use a website, that the web site is responsible for collecting tax on all their sales into that state. Colorado passed a reporting law, and that reporting law doesn't require that remote seller to collect tax, but actually requires them to simply report to the state all the sales into Colorado by all the residents annually. That law was actually challenged and went to the Supreme Court, and within that decision, the Supreme Court stated that maybe it's time to re-examine Quill. And Justice Kennedy, in his concurrence, and I'll quote, said, "The legal system should find an appropriate case for this court to re-examine Quill and another case called Bellis Hess." Essentially inviting the states to create laws that could be challenged and will go up to the Supreme Court to be heard to determine if the Quill standard should be changed. The South Dakota law is a direct attempt at challenging Quill and following Justice Kennedy's concurrence in the DMA versus Burl case that was in relation to the Colorado rule. Alabama instituted a similar law that took effect in January with similar requirements on remote sellers. And again, that law is really constructed to try and challenge the current status quo and to try and get Quill to be revisited. With that said, the law is in effect as of May 1 in South Dakota, and remote sellers selling into South Dakota who have at least $100,000 in sales or have 200 sales into South Dakota will need to register, collect, or remit taxes on their sales into South Dakota beginning May 1. For clients using SOPA's products, that's an easy hurdle to overcome. We simply turn on South Dakota and the calculations begin. For others who don't have an automated system or something in place, you should look at your systems to see what you need to do to see if you're in compliance with this new South Dakota law.